Now our topic for discussion is privity of contract. The privity of contract says that a stranger to a consideration can sue. However, a stranger to a contract cannot sue. When we covered the definition of consideration, it said that when at the desire of the promiser, the promisee, or any other person has done or has abstained or does or abstains or promises to do or promises to abstain from doing something, such act of doing or abstinence, that is of not doing, is called consideration for the promise. So the first line is when at the desire of the promiser, the promisee, or any other person. So the consideration moves at the desire of the promiser. However, the consideration may move from promisee or any other person, as it is clear from the line itself, when at the desire of the promiser, the promisee, or any other person, that is, it may move from the promisee or any other person. Right. So it clearly specifies that a stranger to a consideration can file a case. However, a stranger to a contract cannot file a case. Now the thing is, who is a stranger to a contract? A stranger to a contract is a person who is not a party to the contract. That is, stranger to a contract. Stranger to a contract is a person. Stranger to a contract is a person who is not a party to the contract. Now let's look at a case law for this. The case law is Dunlop pneumatic tires versus Selfridge Limited. Now in this case law, D supplied tires to X, who was a wholesaler. You have D supplied tires to X, and who is X? X is a wholesaler. And what was the condition for supplying the tires? The condition was not to sell below the price listed by D. On the condition not to sell below D's listed price. Now X sold the goods to S, who is a retailer. Now this retailer further sold the goods below D's listed price. Now it was held in this case that the contract was between D and X and X and S. That is, the contract was between the supplier of tires to the wholesaler with the wholesaler, and there was also a contract between the wholesaler and the retailer. There was no direct contract between D and S, that is supplier of the tires and the retailer. So D could not obtain damages from S. So this is no contract between D and S. So D could not obtain damages from S, as D neither gave any consideration for S's promise, nor was he party to the contract between D and X. Thus, a person who is not a party to contract cannot sue upon it even though the contract is for his benefit. Thus, a person who is not a party to contract cannot sue upon it even though the contract is for his benefit. Now, there are certain exceptions to this rule. That is, in the given cases, a stranger to a contract can sue even though he is not a party to the contract. Now, let's look at what these cases are. This is exceptions to the rule. A stranger to a contract cannot sue. Now there are 6 exceptions. What are these? CAMEFT. CAMEFT. C is a covenant. A is assignment. M is marriage. E is estoppel. And F is family settlement. And T is trust. Let's review the points first. Okay, here we go. Privity of contract. A stranger to a consideration can sue. However, a stranger to a contract cannot. A stranger to a consideration. Section 2D provides that a consideration may move from promisee or any other person, that is a stranger. It means that a stranger to consideration can sue provided he is a party to the contract. A stranger to a contract. A person who is not a party to the contract is called a stranger to a contract. Such person cannot claim rights under the contract. This is called doctrine of privity of contract. The following case law explains this point. In Dunlop Pneumatic Tires Company versus Selfridge Limited, D supplied tires to a wholesaler X on the condition that any retailer to whom X resupplied the tires should promise X not to sell them to the public below D's list price. X supplied tires to S upon this condition, but nevertheless S sold the tires below the list price. It was held there was a contract between D and X and a contract between X and S. Therefore, D could not obtain damages from S, as D had not given any consideration for S's promise to X, nor was he party to the contract between D and X. Thus, a person who is not a party to a contract cannot sue upon it, even though the contract is for his benefit. Now, there are certain exceptions to the doctrine of privity of contract. Both the Indian law and the English law recognize certain exceptions to the rule that a stranger to a contract cannot sue on the contract. However, in the following cases, a person is not a party to a contract can enforce the contract. First is a covenant. It means a lawful debt that goes along with the land. Such a debt has to be fulfilled by the future successors. Although the future successor was not a party to the original agreement. This is first is covenant. It means a lawful debt that goes along with the land. Now, such a debt has to be fulfilled by the future successors. A person who purchases land with notice that the owner of the land is bound due to certain obligations created by agreement relating to land shall be bound by them, although he was not a party to the original covenants. Let's look at an example for this. A owns a piece of land on which C is staying as a tenant. The lease agreement has still not expired. Now D wants to purchase A's land. D will have to fulfill or entertain the lease agreement. Second is an assignment. What is an assignment? In case of assignment, there are two parties involved. One is an assigner and second is the assignee. Who is an assigner? Assigner is the person who gets the work done and assignee is the person who will do the work. Now, if the rights of assignee are getting affected, he can file a case against the defaulting party. Or if because of the assignee or assigner, the rights of a third party, that is stranger, are getting affected, then the stranger can file a case against the defaulting party. Who is a stranger? A stranger is a person who is not a party to the contract. So in case of assignment, such a stranger can enforce the contract and can file a case against the defaulting party. Third is marriage. When an agreement is made in connection with marriage and a provision is made for the benefit of a person, he may sue although he is not a party to the arrangement. The case law is Ros Fernandez versus Joseph Gonzalez. In this case, the father of the girl entered into an agreement with Joseph for her marriage. Now the agreement is getting made between the father and Joseph for the marriage of daughter of this person. Joseph refused to marry. After attaining majority, she could sue Joseph for damages for breach of promise of marriage, and Joseph could not take the plea that she was not a party to the contract. Here the girl is a stranger to the contract. However, she can file a case against the defaulting party, that is Joseph, in case he refuses to marry. Next is estoppel or acknowledgement. Estoppel means denying of a statement which has been made earlier. Now, as a general rule in the field of professionalism, a person cannot deny or refuse or prevent from fulfilling the earlier lawful obligation. Where a promiser by his conduct acknowledges or otherwise constitutes himself as an agent of a third party, he shall be estopped from denying his liability to the third party arising from the contract. So now we have the contracts entered into through an agent. This is point number 4. Estoppel or acknowledgement. This is contracts entered into through an agent. The principal can enforce the contracts entered into by his agent provided the agent acts within the scope of his authority and in the name of the principal. Enforce the contracts entered into by his agent provided the agent acts within the scope of his authority and in the name of the principal. Next is family settlement or partition. Now, family settlement here refers to partition. While making the will, two persons enter into the contract. One is a will maker and second is a will writer. Now, in case a person whose name has been mentioned in the will has been prevented from getting his share in order to prevent his rights from getting violated, he will sue the party who is committing such a default. Now, the person filing the case here is a stranger to the contract. Now, there was a case law was named Shuppu Amal versus Subramaniam. Let's look at the facts of this case. Shuppu Amal versus Subramaniam. Now, in this case law, two brothers on partition of joint properties agreed to invest in equal shares a certain sum of money for the maintenance of their mother. Now, the mother is a stranger to a agreement. Held, she was entitled to require her sons to make the investment. Now, two brothers on a partition of joint properties agreed to invest in equal shares a certain sum of money for the maintenance of their mother. It was held she was entitled to require her sons to make the investment. So till now we have covered C, A, M, E, F. There's another point that is left here is T, that is trust, the last point under this. Now a trust is headed by a trustee. Where a trust is created for the benefit of beneficiary, even though he was not a party to the contract between the settlor and trustees to the contract, yet he can file a suit to enforce his right. A trust is headed by a trustee. In case the trustee enters into any secret dealing with the client, because of which the rights of beneficiary are getting affected. Now that beneficiary is a stranger to a contract, however, he can file a case against the trustee. Now let's look at an example for this. A transfers his property in trust to his friend B for the benefit of blind students in his own locality. After A's death, if the trustee, that is B, refuses to give benefit to the property to blind students who are the beneficiary, now the blind students who are the stranger to the contract can file a suit against the trustee to compel him to give the benefits. That is, A transfers his property in trust to his friend B for the benefit of blind students. In his own locality. After A's death, if the trustee, who is B, refuses to give benefit of the property to blind students, who are the beneficiary, the blind students can file a suit against the trustee to compel him to give the benefits. Now with this, we come to an end of our topic, Privity of Contract. Thank you.